A very good morning to you, Terry, and Andrea. I'm sure Terry will actually introduce you as the two of you move forward this morning, but I'm going to hand over to you for now.
Great. Thank you, Sandra, and good morning to everybody. Thanks so much for joining us. Thank you for the partnership with the FIA, which Marsha truly value. And thank you to all the members for joining us. And hopefully we can get some more members to join our portfolio. So this morning I'm going to run through very quickly the summary of the portfolio, and that is really just to highlight and remind and refresh everybody why our product is better in our view, and some of the differentials around the product. I'm also just going to touch very briefly on some of the changes. We try and improve this product every year as we go along. We learn from claims, we learn from changing regulation. So our aim is always to try and improve the product and, to what Sandra was saying, provide the best product out there. Not necessarily always the cheapest, but the best product out there. Once I've gone through that, and there are really only 4 slides on that, I then think we will get into the meat of this discussion, and that is around artificial intelligence and AI. And I'm very pleased to be joined by Andrea today. Andrea, your official title is?
Executive Head of Underwriting and Reinsurance at Cape Part. Good morning, everyone.
And what we want to do today is you will know that I don't love PowerPoint presenting. I'd rather have a discussion with Andrea around artificial intelligence. What are the risks for us as intermediaries around using AI? And ultimately unpack some scenarios where if the AI goes wrong, so whether it's a hallucination, whether it discriminates, or any other issue where the AI goes wrong, what are the repercussions for the broker or the intermediary, and would the professional indemnity policy respond? So I'm going to be challenging Andrea a little bit, so acting as your broker, if you will, asking some probing questions as we go through some of the scenarios. Please feel free to post in the chat questions. We'll do our best to answer them. But yeah, we're going to keep it as interactive, I think, as possible, rather than just presenting. So if we get going on the first slide. Okay, so just a quick reminder, around why Marsh, and I think the main point here is around the placement innovation. Remember that we are the biggest. We place more premium into the market than any other broker. We are specialists when it comes to professional indemnity, crime, directors and officers, insurance, etc. And because of our position as the leader, we really have market leverage. We have great relationships with the market, and that enables us to develop bespoke products for you as our clients. We have the expertise, not only on the placement side, but we have the dedicated FinPro expertise when it comes to claims. I am head of claims advocacy for Marsh, and I can tell you, out of all the classes of insurance, professional indemnity, crime, directors and officers, and cyber are probably the most complex. But we do have that expertise when you need us most. I think that's really important. We operate with absolute transparency. We earn a commission. We do not charge any other fees, any other management fees, and we operate with absolute transparency. A lot of you on the call who are members will be familiar with the team, which is headed by Zach Ranyani, and you would have dealt with Tim Makile and Hamotso. So we have a dedicated team that deals with our intermediaries, all experts in what they do. And I think very importantly, we have a national presence as well. So we're not just based in Joburg, we are in Durban, we are in PE, and we are in Western Cape. So, we really are specialists in what we do. Okay, so if we move on to the next slide, really just reminding everybody again around the coverage enhancements, and I'm starting with the directors and officers. The D&O cover in the open market is not an extension, whereas under the FIA portfolio, there is an automatic 2.5 million rand of D&O cover. I want to stress, however, and I hope this is being recorded, this is not a full directors and officers liability policy. So for those of you that from a risk profile perspective are worried about the D&O exposure, I would urge you to look at a separate standalone D&O policy. And the reason I say that is because this 2.5 million doesn't contain any of the usual extensions we would find under a D&O policy. It doesn't have company reimbursement. It's only for the directors, so we would call that side A. And it's limited cover. It's limited, in fact, to breaches of Section 77 and 78 of the Companies Act. So that is quite limiting. So I would regard this as very important cover, but it's contingent cover. We've got the fidelity guarantee, and we've got the highest sublimit. As you can see, we've got loss of documents at a higher sublimit. We've got a higher sublimit for regulatory expenses, as well as for statutory defence costs. We've introduced the cyber breach defence costs, or cyber breach costs. I think this is the third year that we've had this coverage in place, but it was optional. And then in January of this year, we now included it automatically. It's a small limit of 250,000 Rand with an excess of 20,000 Rand, but it is very, very important. And these are cyber breach costs. So in the event that there is a breach, this is the costs for you to appoint an expert, whether it's a forensic investigator, whether it's a lawyer, to assist you in A, detecting the breach, in B, managing and closing out that breach, and then very importantly, advising the regulator. I don't think a week goes by when one of our clients don't have some form of cyber breach. It is mandatory that you report this to the POPI regulator, and a lot of our clients are really struggling with what that looks like. So knowing that you have 250,000 Rand of cover available to breach, to brief those experts, I think is a really important coverage enhancement that we've introduced. And then, of course, you've got your third-party cyber liability. It'll differ in the open market, risk to risk, but the FIA policy comes with a 5 million sublimit. Again, I want to just reiterate, this is not full-blown cyber liability policy. So you will not, for example, have the business interruption cover. You will not have a number of extensions that come with cyber, ransomware, etc. And again, to the extent that you are worried about your risk profile from a cyber perspective, there are many solutions for small to medium-sized businesses out there in the market for you to buy your cyber liability. So treat this as contingent. And then finally, maximum limit still remains at 100 million. If we move on then to what's in scope and out of scope, nothing much has changed here. Not to say that the out of scope risks can't be written by LEPOD, they just are written on a good basis. So FSP entities, if you have a Cat 2 license as well as a Cat 1 license, we've got a few clients like that are on the facility or on the portfolio, and that just depends on the size and the scale and the size of the assets under management. So it is possible we can cover that under a portfolio. Revenue not exceeding 75 million, over 75 is a referral. No claims in the past 5 years, that just becomes a referral. Aviation, provided exposures are less than 50 million Rand, and then you just have to answer some additional questions. Marine, small craft and goods in transit only covered, less than 50 million Rand exposure. We spoke about asset managers. Incidental tax advice, provided no more than 10% of total turnover. And then you can see on the inter-vivos trusts, it depends. Out of scope, the big guys, the banks, the insurance companies, the pension fund administrators and pension fund trustee cover, stockbrokers, derivative forex traders. LEPOD really don't like crypto. They really don't like crypto. We've had lots of discussions around crypto. It is an exclusion, but the advice element is still covered, and then UMAs as well. So nothing much changes around the scope.
It's just critical to note that in terms of Cat 2s, I mean, there aren't many markets out there that will provide PI cover for Cat 2s. We have a bespoke asset management policy that will benefit your clients.
Good. And then finally, just insofar as renewal is concerned, the good news, I mean, you spoke and we listened. The complaint that we had was that you were having to complete a full proposal form every year. We've now agreed with LEPOD that you only need to complete a full proposal form every 3 years, and in the interim, no claims declaration will suffice. I think that's great, but the only caution I would alert you to is that there are risk management protocols within your policy that are suspensive conditions, so don't lose sight of that. And that's not just from PI exposure, but also from cyber exposure. Don't lose sight of those risk management protocols because they were contained in the proposal form and now they won't be in the claims declaration. Please ensure that your claims question is fully and correctly answered. We've got the after inquiry. Make inquiries within the business if there are any claims or circumstances which could give rise to a claim, because the policy requires us to notify those. We never want a situation where we haven't notified the claim. It becomes a claim over a renewal. You know, we're then in a difficult position trying to get that claim admitted. The information contained in the proposal form forms the basis of the quote, as well as the no claims declaration. So if you say there are no claims, Leopard are going to believe that there are no claims, and then just make sure that if you do need to answer the additional questions relating to marine aviation, etc., do so. We do need a copy of the audited financials every year. If your 26 are not available, then just give us, or 25, give us the year before that. And then obviously from a claims data perspective, it is essential that you give us as much information when there is a claim. We've triaged some claims on this platform before, so I won't touch too much, but the bottom line is that more information is better when it comes to claims. Please submit your renewal information early. It doesn't help us if you submit your proposal forms to us a day or two before renewal. We hate hold covers, we hate extensions. We believe that from a legal perspective, there are a number of issues that can arise. By all means, test your market. You know, if you're not with on the FIA, you're not with Leopard or Marsh, by all means, ask us for a competitive quote, but please don't do it the day before renewal. We have strict KPIs that we agree with Leopard. Generally, we turn quotes around within 24 to 48 hours, with policy documents between 4 and 6 days. So if you come to us a day before, you know, cover's going to expire, it's highly unlikely that we're going to get that quote to you. It's possible, but unlikely. And then last point is just any 2 consecutive unpaid debit orders on a monthly basis, then the cover will automatically result in cancellation. Okay. Right, so sorry, I went through that quite quickly, but I want to get into the meat of it. And I think while Andrea's calling up those slides, you know, the question is how far? Yes, Sandra.
Apologies. So there is a little bit of a distortion on the sound. So if I can just ask that you try and get yourselves as close as possible in front of the mic, just so we don't miss the interaction and what you say.
Hear us now.
Just lean a little bit in to, I think you might need to even get a little closer.
Okay.
Okay.
Now you can really see all the wrinkles.
You look wonderful.
Great. Good.
All right. Thank
So
you.
I think while Andrea calls up the slides, you know, I think the question that we asked ourselves is how far should we go? You know, AI is here, whether we like it or whether we don't. In fact, I think we can all agree that we're now in the age of agentic AI, where, you know, large language models are now making decisions on behalf of the human. We can all debate whether that's a good thing or a bad thing, and I think we can have some of those discussions. But the big question is that as professionals, we are going to be using AI more and more. And if we use that AI, particularly to advise clients, and we get that wrong, will the professional indemnity policy respond? What are our duties and our obligations as brokers and intermediaries when it comes to relying on AI in order to advise our clients? When does the AI become advice? And what can we do to mitigate our exposure when we are using AI? So that really is the question that we wanted to ask. But Andrea, I'll turn over to you to go through the first couple of slides.
Thank you so much, Julie. Can you see my slides, Sandra?
And Andrea, from our side, also just to note, I see Lazal's hand was up.
Apologies, we can't see that. Lazal?
Yeah, thank you very much, Terry, for your presentation. And maybe before Andrea kicks off on the AI presentation, I just wanted to highlight something in your presentation which jumped out at me, in particular around the comment on hold covered. I think it said something around the lines that Cover could be prejudiced if, we request for a hold covered period. And I think maybe just as a follow-up from this discussion, we would need to pick that up with Marsh just to really understand what sort of proactive communication will Marsh be implementing to guide our members around that particular point that you raised in your presentation, because I certainly know from an intermediary perspective that holding covered is a very common process that intermediaries follow. So just maybe to give some thought to how Marsh can support a proactive communication around that. Thank you, Terry.
Happy. I've made a note of it. Good. Andrea, over to you.
Thanks, Terry, and thanks to the FIA for hosting us today. I think before we start, this is not an anti-AI talk. AI is here. It's incredibly useful. I have personal experience thereof, and it's changing the way we all work. If you use it well, it can save time, improve efficiencies, and it also helps us deliver better outcomes for our clients. Today's discussion isn't about whether you should use AI. That ship has sailed. The real question is, where do we draw the line between artificial intelligence and human judgment? Okay, what's interesting is, as at last year, November, only 8% of South African insurers were using AI. Now, bearing in mind that was 7 months ago, a lot has probably changed since then. I do see more and more markets embracing the use of AI in their day-to-day businesses. It's tiny in relation to banks that were at 52% last year. Insurers might be behind. I, however, see this differently. I think it gives us a window to get the governance right before AI becomes business as usual. The risks aren't waiting for us. Deepfakes impersonating FSPs, business leaders, and even the FSCA commissioner already being used to deceive the public. And then we also had a recent case in KZN where a junior attorney presented documents in court. 2 of the 9 case citations were hallucinated by AI. Now, AI simply invented most of these cases that were cited. The risks are on the horizon. Sorry, these risks are not on the horizon. They are already here. Okay, there was the Air Canada case with the chatbot. I mean, this was quite contentious. You do see a number of insurers embracing the use of a chatbot. And Terry, I know you had some thoughts around that.
We were discussing how I hate chatbots.
Yeah.
I hate them. And there was a recent survey. It was a US survey done by a company called Corolla. They are actually an AI consumer services company. So they interviewed over 1,000 Americans. I think it's 1,001 Americans. And it is interesting that more than half of those surveyed actively tried to circumvent the chatbots. 43% said they had yelled human or person in an attempt to speak to a customer service, to speak to a human. 17% admitted using profanities, right? How many of us have done that? To try and break free of this automated bot. 4 out of 5 said that they would, this is very interesting, 4 out of 5 said that they would abandon the brand if the customer service became too automated. So insurers and brokers, us as well, we need to think about that. We don't want to automate our business too much. That human in the loop, that human connection is absolutely critical. And what struck me as the most profound is that 30% said that they did not trust the AI. So I hate bots. They are here to stay, these chatbots, there's no question. But if you think about 43% had shouted the word human or person, they wanted to deal with the human. So,
yeah. I mean, with Air Canada, this is the perfect broker parable. A chatbot promised a discount that didn't exist. The tribunal held the company responsible. So your tool's words are your words. So the lesson in this is, with chatbots, the output is yours. You own it regardless of what it generates. So be mindful of that. The next one was Clone Faces endorsing scams. I mean, they are using figures that we all know, deepfake videos of Elon Musk, Jan Rupert, and others being used for a fake AI investment scheme. Investors were funneled to a licensed FSP. The FSCA withdrew the license and imposed a hefty penalty. So the lesson there is always verify the source. And then last was the digital heist. Now this is, I mean, gosh, I didn't ever think I'd be talking about something so soon. A digital heist.
Yeah, happened.
It's mind-blowing. I mean, this guy was called into a Teams meeting. He said, the CFO said to him, listen, I know that this is unusual. We do have our protocols in place, but let's quickly jump onto a Teams call. I'll get some of your colleagues in as well. And everyone in that Teams meeting were deepfakes other than the individual concerned. And he went and he released funds. I think critical is ensure that you have payment verification protocols in place, and that forms part of your PI policy as well in terms of your cyber third-party liability extension.
Yeah, and talking about deepfakes, I mean, what would you say are some of the things that as brokers we can look out for these deepfakes? You know, I mean, these days we say when you get onto a Zoom or Teams call, blink a few times, wave your hands to prove that you're a real person. But I mean, are there any other things that you can think of that, you know, brokers can think about, not just on deepfakes, but when they receive those calls from the bank, supposedly, what are some things that we can do?
I mean, you would have contact individuals on file. Contact the individual. Don't use the number on the email that was given to you, because chances are they're diverting you elsewhere. Look at the file, at the record that you have on file. Verify that. Be very mindful of where the funds are going, because you are going to get caught. That's for certain. And we've seen it. We've seen it locally as well as globally.
Problem is the deepfakes are getting better and better.
Exactly. The concern is, I mean, we were having a chat the other day in an EXCO meeting, is that your voice is out there for everyone to see. And well, for everyone to hear, and they can use your voice. The other thing that was very interesting is, and I'm sure a lot of you on this call have been in recent AI training sessions. The one thing that really stood out for me recently during a training session was watch your fingerprints. When you're posting selfies of yourself, your fingerprints are out there and they can actually duplicate those and use it to commit fraud. I mean, how scary is that, Jenny?
Stories. We should all go back to post.
Faxes. Yeah. Okay, so AI has moved from back office admin into advice, and that is the danger zone to you yourself as an intermediary. I'm sure it's proven quite useful in terms of your day-to-day.
Absolutely. I mean, you know, we're Marsh, we're a massive organization, so we have our own AI tool. It's called Len AI, and I use it every single day. As I say, claims advocacy, I use it every single day, but I use it as the enabler. The tech is the enabler, and I am what I call the point. So yeah, every day it's part of my life now, very much so.
And I think, I mean, the difference here is, Judy, whilst you have this as a tool, I mean, we need to coexist with AI. And it is the way of the world, and we need to embrace it. But we can't take everything at face value. We need to interrogate the data, the output, because the clients are paying for your judgment, not the model's output. So I think that's the critical part there. Yeah, we just need to reiterate today. You can delegate the task, but you cannot delegate the duty. The chatbot is not going to sit in front of the ombud and please explain why a hallucinated advice was given to a client. You as the professional need to. It's your professional reputation that's at stake. For example, PIA already govern automated advice, but there is no firm law in place as yet governing AI, but it's coming. Believe me, it's coming. And I mean, already we're seeing overseas, a lot of the insurers are putting in place restrictions or just removing cover in its entirety. So just be mindful of that, but it's prudent, that you put in the necessary protocols to future-proof your business.
I think on that, Andrea, especially from a regulatory perspective, I mean, we know that the regulator tried to put out an AI protocol. Unfortunately, some of it hallucinated. They used AI and it hallucinated. So they've had to withdraw that, but it's coming whether we want it or not. Doing some reading on what that's going to look like. I think what's great about South Africa is that we are going to see a hybrid approach when it comes to AI regulation. And what the government is going to do is that they will look at the economic impact as well as, very importantly, the societal impact.
Yeah.
And let's not underestimate the societal impact in the socioeconomic environment that we're operating in. I think, Sandra, you said it, everybody's scared that the robots are coming and they're going to take our jobs. That may be a very real thing, in African and the South African context. So I think it's important that we focus on societal impact. And the good news is that it looks like the government is going to do both, which is fantastic. The other point I just wanted to make is, you'll see there, this applies to the FSP as an legal entity and the DMOs.
Yeah.
This is so critical. What we are seeing, not in South Africa yet, believe me, it's coming, in the US, is we've seen a number of directors and officers' actions. So this is actions brought against the individual directors and officers for what we call AI washing. So we're all on this AI train, there's no question about it. We all want the competitive edge. We all want to be better and say that we're better than our competitors. But when it comes to mis and disinformation around the use of AI or the development of AI, and shareholders and stakeholders are relying on that information put out by the board, and it's proving to be wrong, you're seeing class actions, you're seeing regulatory intervention. UK company fined £500,000 for overstatement or mis and disinformation relating to the AI. So again, it hasn't happened in South Africa yet, but it will happen at some point, because I would say, window dressing is not an option. Don't window dress the AI. Say what you do what you say. That's really important. So yeah, the directors and officers' exposure is enormous if they get this AI wrong.
Yeah, I mean, if I were to say by show of hands, how many of you use AI today?
Exactly.
Okay.
And I think the other point just around King, you've got it there. It's an important slide. We may not have AI law specific yet. It's coming. It's definitely coming. There's no question. But at the moment, we've got the FSCA, we've got FASE, and we've got King. And King is the governance code. And where we're entering now is this phase of AI governance. And that's what we're talking about a little bit more, is how do you mitigate the risk of using the AI? Well, it's all about governance, right? It's about having that protocol in place. It's about meeting King 5, because King 5 makes AI a board oversight issue. So you as owners of your business, or you as directors of the business, have an absolute duty to read King and to implement what King contends in your businesses from a mitigation perspective. So yeah, King, don't underestimate it, because our courts have ruled, there's plenty precedent to show the fact that they rely on King from a governance perspective when making judgments.
Yeah, remember, in terms of your policy, you need to comply with all laws governing your business. I mean, that's key. Okay.
And then that negligence test, so Kruger versus Coetzee, is that sort of still the benchmark?
Absolutely. I mean, so the question here would be, let's say there is an issue, a case of there's been an hallucination, advice has been given to the client, and there's now a claim, and that advice was incorrect. So what they'll do is they'll ask, would a reasonable intermediary have foreseen the harm and taken steps to prevent it?
That'd be interesting.
Yeah,
Good.
okay, I think we can slide. Here's the uncomfortable truth yet again. Hallucination is a real danger, right? it's a human accepting the answer without questioning it that's even more dangerous.
Absolutely. So that's human in the loop.
Always, always. I mean, Terry, you have junior people coming into your organization and you're putting AI into the hands of these junior team members. And let me tell you, if the AI has hallucinated a response, they're not necessarily going to pick that up immediately. But to the trained eye, a seasoned professional such as yourself, Terry, I mean, you can see it a mile away, but they won't. So it's really important to actually have some form of AI governance in place.
I presented to a listed board a couple of weeks ago on directors and officers, and I was doing some research. And there's a recent South African case as an example. Now, I knew the case, and I asked Claude to...
That's my briefing, by the way.
Yes.
Love Claude.
I asked Claude to summarize the case for me, and what Claude did is to summarize the case, but it named the defendant as a man. Sorry, the plaintiff as a man, where I knew that the plaintiff was a woman. Now, can you imagine if I hadn't have checked that or if I hadn't have known?
Exactly.
And I presented to a listed board that the plaintiff in that case was a woman. So that's a great example of where it hallucinated. And I asked it then, are you sure? It came back to say, actually, you're right. So you make a great point about that experience. The youngsters must have that human in the loop oversight from the normal experience in the business.
Okay, I think I'll hand over to
Yeah, and I think before the top, well, mind you, we can go into this. So I think from an AI and PI perspective, just focusing on some of the bigger risks, the top 10 risks. The first, Andrew, you've already alluded to it, and that's the hallucinated cover. You need to watch out for the hallucinations, to have that human in the loop. I'm going to say it over and over again, but it's absolutely critical. We'll provide you with some examples of where the AI can hallucinate, both from a coverage perspective or interpretation of the policy. The AI can hallucinate on coverage and providing coverage where it's actually not there. So we must be very, very careful about hallucinations. We've spoken about the over-reliance and the skill fade, right? This is where your professional judgment is handed over to the model. We are in the age of agentic AI where the large language models are making decisions. They're making human decisions. If we're not checking that, okay, and we're allowing the AI to make judgments without checking it, we're off asking for trouble. The allegation will be a breach of duty of care. You have a duty of care both in terms of phase, as you all know. From a directors and officers perspective, you have a duty of care to your shareholders, and you have a duty of care. It's profound. So the allegation will be if you have provided AI that your client has relied on as advice, and something has gone wrong, there's a claim, they took that advice, the breach of duty of care will be raised. The POPI and the data privacy is absolutely critical one. Please, please, please do not put any of your client information into any public AI tools. Do not use OpenAI to put your client's personal data in. Unfortunately, we do see it happening. Rather invest the money in a closed system where you can safely enter your client's details. I think that's really important. The AI can hallucinate, it can provide biased and unfair outcomes, and this largely depends on how you prompt the AI. So a good example, actually, I think it's a real thing that happened, is the broker asked the AI, so the client wrote to the broker and said, I'm opening a business in a particular area. Okay, it was in a low income area. So what the broker did is they asked the AI whether the insurance premium would be more expensive in a low income area, okay, in a Hispanic low income area. And the AI came back with a profound, yes, it would. So then what the broker did is it wrote to the client and it said, well, based on this, there's only a limited number of insurers that we can go to. okay, who will underwrite in this area and this particular risk. So the broker took that at face value and didn't approach all the markets. So you can see how the AI was completely biased and that the broker breached their duty of care to go to the market. So that's a good example of bias and unfair outcomes. The explainability gap, you said it earlier, if you cannot explain why the advice was given and the basis on which you ask the AI for that advice, it's going to be impossible to defend a claim against you. You are going to have to show what prompts you used. You're going to have to show how the human in the loop questioned those prompts. That's absolutely critical. And you are going to have to explain and show to the regulator, the ombudsman or the court, the evidence. You're going to provide that evidence. It's critical. If you've got the explainability gap, I think it's going to be difficult. Again, confidentiality and the IP leakage, that's very important. The third-party vendor dependency, and these two go hand in hand. The reason I say that is because if you look at the third-party vendors, whether these are the developers of the AI, these are people implementing the AI in your business. I don't know if any of you have read the terms and conditions of Claude, ChatGPT, etc., etc. If you read them, you're going to hesitate about using them because the bottom line is they contract out of liability for almost everything. They shift the risk back to the user, okay? And so it's not that you can blame the algorithm, and you cannot blame Claude, and you cannot blame the AI. I think that's really important. Spoken about the deepfakes and the fraud, and then the AI generated evidence, which was spoken about. So I think these are some of the risks facing us as brokers going into the future. So these are some of the examples that we came up with. I think some of them are very relevant. We were all holding our breath on Tuesday, right, around Sasria. But here's an example of the AI. So the broker asks the AI to confirm whether riot, looting, and injuries in particular are covered under Sasria. And of course, the AI says, of course it hallucinates because Sasria generally does cover these things. Based on that, the broker advises the client. But what the junior broker doesn't do, to Andrew's point, is it doesn't have a human in the loop. He or she doesn't have a human in the loop. They simply pass on that information because that's what AI said, but they don't check whether Sasria was actually correctly placed. So they don't simply open and click on that folder to see that the Sasria coupon is actually there. Of course, that amounts then to a false statement. Okay, there's a claim, whether it be for property damage, whether it be for looting, and of course, that claim is repudiated. And that, to me, is a clear-cut case of where we would come to you, Andrea, and say, well, we think this claim is covered, and you're going to argue differently. Okay. The other example is underinsurance. This is a hired implant. So the broker asks the AI to confirm whether they're not necessarily an expert in this field. So they ask whether under construction or risks policy, hired implant will be covered. And of course, the AI says, yes, of course it is, because it's generally, beware of the words generally when AI generates. Generally, it's a standard policy, a standard term in the policy, and therefore covered. Of course, the leased excavator is stolen, and they don't have this cover in place because there was an exclusion. Wasn't checked. Okay. Another example is the bias risk scoring, which I gave you another example earlier of, but this is where discriminatory proxies like protocols steer the client to a harsh security warranty. So I keep my car in, again, a low-income area or a very unsafe area, and the AI hallucinates or produces a bias risk scoring such that the broker relies on it, doesn't do the full market exercise, and therefore discriminates against the client. Okay, that's another example. And then we've spoken about the chatbot. So, yeah. So these are real examples, right? I think they can go wrong. So the question then to you, Andrea, of course, as the broker, is, well, of course this is covered. And why do I say that? is because if there were to be a claim made against the broker, this is a claim made for negligence that causes damage to the third-party clients. Okay, and in terms of your wording, which I've reviewed 100 times, there's no AI exclusion. So I would argue that those examples that I gave to you should be covered. What's your response?
I think the biggest caveat here, Terry, is that responsible use is encouraged, and in fact, you have to use AI responsibly. And I mean, that's been the mantra we've been saying all day long, I mean, all morning long. Leopard as a market, I'm sure a lot of you on this call have had interaction with us. The magic that is Leopard at claim stage, I mean, it's just unmatched, Terry. We certainly look for ways to pay claims. And whilst we'll look at the merits of the claim, if at some point we can ascertain that there was no human output, there was no oversight, that does become a challenge for us. We need to be comfortable that as a risk that we're currently insuring, that you are prudent in your approach when you're dealing with your clients. We need to be comfortable that you are abiding by the laws governing your business. We need to be comfortable that all the checks and balances are in place. And if we are comfortable, chances are 9 out of 10 times your PI policy is going to respond. We are not going to hide behind the T's and C's of the policy at all. What we like to do is we like to get into a room, sit around the table and talk through a claim. We don't like to at the onset say no. As I've said earlier on, we do prefer, we look for ways to pay claims, and that sort of, it's embedded in our DNA. It's just what we say.
So I'm hearing, the terms and conditions are important. And if you look at some of the terms and conditions around giving more reasonable assistance, around full disclosure when it comes to notifying a claim, that's fine. But I'm hearing that if they haven't followed proper protocols around human in the loop, which we're going to talk about, and some of the other protocols, that you may then question their blind reliance on the artificial intelligence. So I guess the next question would be, what if a client, as an example, has taken steps to mitigate? So they have checked that. The question I'm grappling with, and I don't know the answer, is in South African law, whether the prompts will stand up to legal muster. So I can prompt the AI, and I can show you how I prompted the AI. Will that stand up in discovery, as an example, in South African law? I don't know the case yet, and I don't think it's contested. So I think that's the one question. And then the other question is, if I were able to show you how I prompted, and I showed you that there was maybe human in the loop, there was, oversight. Do we have lawyers in South Africa or law firms in South Africa that really understand the space that you guys use that would assist in defending the broker? Remember, the plaintiff has to prove their case, right? So they have to prove that there was negligence, causation, liability, and fault. They have to prove that, and damages, sorry. Negligence, fault, causation, and loss. They have to prove their loss. So they have to say, I relied on advice, even though it was AI generated. As a result of that, I suffered a loss, and I had to prove the nexus. So I have to prove my claim as a plaintiff. But you'll defend the broker. So if I can provide you with those prompts, would it stand legal muster?
You certainly are putting me in the hot seat. I thought we were partners, Terry. Look, quite frankly, Leopard as a business have employed degreed professionals. So all our claims personnel are degree professionals. They all have their legal degrees. Secondly, we deal with the top law firms.
Right.
I mean, we believe that we need to sort of have the experts in the room when we're dealing with complex cases. And to my mind, with AI, whilst it may not quite be complex, I suppose it usually would be a clear cut, yes, it's covered, no, it's not. But I think because it's still so fairly new, that we should still continue to gravitate towards the experts to guide us in terms of how we need to approach the claim when it hits our desks. And I just definitely.
Yes, again, I don't know the answer. Maybe there's some members who can answer that. And I think the body of law around AI in South Africa, as around the globe, will need to be developed. But I think it's an important point to make because we're advocating for brokers and intermediaries to ensure that they keep records of the prompts, that they keep records of human in the loop, etc. But we need to know that it will stand up to legal muster if it's ever changed. So I think that's an important point. And then you've got conditional deepfake or voice impersonation causing third-party financial. Let's just talk to us when you say conditional. What do you mean?
So remember, in terms of your cyber third-party extension, we do have certain protocols that need to be followed. So in terms of payment protocols, have you followed all those? And that's why the cover is conditional, provided that you've met the terms and conditions that we impose, the policy will respond. I think it's also just important to note, Terry, I mean, sometimes it can be daunting looking at the policy wording, looking at these protocols. But I tell you what, when you really look at those protocols that we've listed, it's literally not rocket science. It's not going to cost you an arm and a leg to sort of implement. It should be happening in your day-to-day anyway. I think what we're doing is just reiterating that it needs to be applied.
I mean, I wrote them down, so for everybody's benefit, the security protocols in particular are up-to-date patches. We should all have this in our business. Backups, authentication processes, firewalls, and then password and access policies. I mean, like you said, these are just basic security features that every business should have. So we're not asking anything unreasonable, though, which I think is important. Okay, and then the unlikely to respond. So you talk about the reckless reliance on AI, and we've obviously spoken about that. I don't like the you knew was unreliable. I think I test that from a legal perspective. So the reckless use of AI would be simply asking the AI and then taking what
trusting it
blindly. Trusting it blindly. So I would probably agree with you that from our perspective would be difficult to get over the line. The AI advice outside your FSP license category. I think that's an important one, right? So you're only going to cover what the FSP is licensed to do. Okay, and I think just make a note of that, everyone, because that's important. It's not that you can give blanket advice outside of your license. And then the POPI breach, if you're going to use OpenAI and put your client's data in, you're probably not going to cover that. We'll try and find for you, but I think that's going to be a difficult one because I would argue that that's pretty reckless.
Absolutely. I mean, it's privileged information. You can't put that out onto an open AI platform. It just exposes the client's details, and that's not what a professional should be doing.
Good. Okay, so that's good. So whilst you, I think this stands to reason, right? If the AI was used responsibly, with human oversight, sound governance, and a clear audit trail, and a genuine legal liability for negligence arises, the PI should respond, subject to the terms and conditions. I like how you put that in. But that's what it boils down to, right? Responsibility. And I think the other thing is around the ethical use of AI. It's so critical. And it talks to the values of the business. This has to be a tone at the top thing, right? You need training. We're going to get onto some of the mitigation protocols. But you must use AI ethically. I think that stands to reason. And that should be used throughout the organization from top down. That approach to using ethical AI should be a cultural issue of the business. So I think what responsible use looks like, right? A written AI policy, absolutely critical. I think, Andrea, a question around that, you know, if you look at the regulatory environment that we're operating in now, we've got regulation, we've got phase, we've got treating customers fairly, we've got audits, it's tough. For the smaller intermediaries, I mean, is this possible? Is this realistic for them to have these AI protocols in place?
Absolutely, they don't have to incur any cost whatsoever, so cost is not an issue at all. I mean, this is literally a case of you sitting down in a room, you saying to your HR individual, right, we need to update our HR policy procedures. What does this look like in terms of AI? What repercussions are there for individuals using AI irresponsibly?
Right.
So, I mean, it's literally going back to basics here, embedded into your HR protocols. It's really not rocket science. It's practical.
As is the human in the loop, right? I think the thing on the human in the loop is we would say, just make sure that it's a competent and fully phase accredited person who is providing that human in the loop oversight. POPI guardrails that should be part and parcel of how you do business. Just remember that if there is a breach, it's very important to know what those POPI guardrails are. And then a documented, saved audit trail of what the tool produced and what you checked. That, I think, is going to be absolutely critical, right? So you need to be able to show how you prompted the AI, what the output was, how you then intervened from a human in the loop perspective, what you changed in your response to the client. I see a lot of the bigger brokers and a lot of the professional advisory firms will say that we have used AI to generate some of these answers. You know, and you may want to get legal advice around that. But this documented audit trail is critical when it comes to any professional indemnity claim, whether you've used AI or not. You know, so we say make sure that you've got the documents because that helps us when you have a claim. And then regular review and monitoring of your AI use. That's very, very important. So we talk about that audit trail. You know, don't let the juniors just use AI and you don't know to the extent in which AI is being used in your business. That's very important. And then the final point, which I think I've spoken about, is you know, that ethical use and cultural imperative. Training. If there's a tone at the top and everybody knows what the business's ethos is relating to the use of AI, I think that's an important mitigation step. So yeah, bottom line is I don't know, simply not an excuse going forward. So it sounds a little scary. From a South African perspective, I haven't seen any markets yet exclude AI, whether that's in a property program, whether it's in a D&O or cyber, etc. I haven't seen exclusions. I've seen it in the US, so there are some markets that are starting to either limit, sublimit, or exclude AI. Do you foresee a time that might happen in South Africa? And what are some of the factors that you would consider in making a decision from an underwriting perspective?
It's a really good question, Terry. I personally don't think that cover should be restricted or eliminated because as far as I'm concerned, AI is being used in your day-to-day. I think what should rather be done is, I mean, we serve with insurers, we go through our treaty conditions, and trust me, they're starting to ask questions. They literally are. What one needs to bear in mind is, whilst that's my personal opinion, we are part of a much larger ecosystem. So in order for us to provide you with support, insurers need to support us too. I mean, you could say Leopards are experts when it comes to PI for FSPs. So reinsurers will go, let's leave Leopard, they know what they're doing, you know. Conversely, they could go, well, this is not sustainable any longer, Leopard, what are you going to do now? What I can say is, whilst we have started to have these discussions with reinsurers, they're not imposing anything just yet. Look, we usually are slightly behind the curve in terms of what overseas markets are doing. I do anticipate change, and the only change I do anticipate is probably at underwriting stage, Terry. So we might say to you, listen, here's 2 or 3 questions that we need answered. It literally is, it's just for us to be fully aware of the fact that you're taking this seriously and that you do have protocols in place. And yeah.
So it's just another emerging risk. I think the difference is the speed and the pure speed at which this thing is developing, absolutely. And then there's that human element. And I think what a lot of the insurers are probably grappling with is how do you underwrite this, number one. Because of the speed, the data is just simply not available. So how do you provide an algorithm that underwrites this exposure when we're only at the beginning? But it follows, or it's following, I think, much like cyber did, right? We had the same discussions.
Yes.
When cyber was up and coming, we thought, my gosh, this is the next big emerging risk. You know, what's going to happen? And look where we are now. Everybody's buying cyber liability insurance, and you can underwrite it, and there's information. So to me, it is another emerging risk. But I think it's the scale at which it's developing that it's going to present some challenges. But that's what's exciting about it. So yeah, I think your final slide says that, or before we go into questions, you know, and that's that the duty of care, to reiterate, the duty of care is with you, not the tool. Very important. You've got to use it responsibly. If you do, and you've taken the mitigation steps and provide the evidence, we do believe that the policy should respond subject to the terms and conditions. And I love this, that human trust is the premium that clients pay for. AI is the enabler. So I think that's a great way to maybe, Sandra, segue into questions. We can't see the questions yet unless we stop sharing.
Yeah, we can stop sharing our slides.
Stop sharing.
We
Yes.
saw some hands going up, but we could see.
I think Andrea, you had indicated like a hand up if you were utilizing AI, and all, you know, we could just see 1,000 hands popping up all over. So
And help us with that. Were a lot of people, there were lots of hands up?
lots of hands up for specifically that, yeah. So I think in terms of some of the Q&A that I've seen here, our CEO had raised a question, but I think you've answered it already in terms of the coverage, which says likely to respond when a human reviews and signs off, but unlikely for reckless reliance on AI. But I think you've now covered that subsequently since that question came up. But I think a very important question and developing by my understanding from the conversation that you've had now. There were some questions around secure alternatives in terms of what sort of AI, and I think that's very difficult. I would hate to put you all on the spot. We've talked about Claude, we've talked about OpenAI. There were some questions, what is the difference between OpenAI and a closed? And obviously, you're welcome to touch on it, but one would be your paid for, one is your free.
Correct, yeah. Correct. So if you pay for it, then you have certain rights so that the information is secure. So yeah, whereas opposed to just Googling ChatGPT, Googling Claude, and asking it a question. That's what we don't want to use. You can use it generically, but don't put any confidential information. The problem with these large language models, remember, is that they learn. So Andrea she loves Claude, and Claude loves her back, believe it or not. So what the LLM does is it learns, and it learns you, right? So the next time, after a couple of 100 prompts that you've given it, it starts to talk like you, it starts to react like you. This is what LLM does. So just be very careful about putting even your own personal data, into an OpenAI platform. Rather pay for it. Rather pay for it in your personal capacity. And don't put your personal information like your ID number, your home address, and your telephone number. You just don't want to be doing that kind of thing.
No, completely agree. I mean, we at Leopard, we currently we're testing or piloting a new system at the moment, because to our minds, we want our underwriting team, we want to future-proof their roles. And in order to do so, what does the future underwriter look like? The future underwriter is using AI as a tool, but they're still focused on the relationship element. But I think what it does is it's going to elevate You know, it's basically theory on steroids, you know. You're not changing the essence of what you do and who you are, but you are literally using it as an enabler to elevate your professional status.
Correct. I think that's a great way to cover that. Our CEO has a hand up here, and we've specifically given her the mic so that she can come in and ask some questions. So thanks, Lizelle.
Yeah, thank you both ladies for your presentations. Do you have any practical examples to date of where you've seen AI use within FSP advisory businesses and how that is being sort of dealt with? Do you have any practical examples, or are you still dealing very much on theory? And yeah, maybe you can just give some context around that.
Yeah, so I think, Lizelle, from a PI claims perspective, no, we haven't seen it yet. I think it's coming. So from a pure PI claims perspective, no. But I think if we had to ask every single intermediary here, you know, are they using AI and have they used AI to provide advice to clients? I think the answer is going to be yes. And the examples that we put up, you know, around the Sasria, around the motor, around the AI hallucinating when it comes to coverage, etc., etc. Yeah, I think if we all look in the mirror, we are using AI to advise clients. We have the human in the loop. I mean, we're a global organization, so we have lots and lots of protocol that we have to follow, you know. But I think everyone, I'd be interested if the brokers on the call, you know, could confirm, have you used AI and then use that response to advise your clients? Even with the human in the loop, even with all the mitigation steps, I think the answer would be yes. But no PI claims that I'm aware of that have resulted.
Yeah, I'd just like to add to that. And yes, at Leopard, we haven't seen any claims as yet, even in the open market space. So it is an interesting one to keep an eye on. In terms of brokers using AI, so the question for me is not so much if AI is going to take over your job as an intermediary. I think the question is, will brokers using AI take over the roles of brokers not using AI? I think that remains critical. Yeah.
Yeah. Thanks, Andrea. Thanks, Terry.
Thank you. We have obviously shot over time a bit, but I think there were some questions we definitely wanted to cover. And I think just there is one question specifically related to the scheme here. Terry, is there a limit to the turnover as to what can be written on the scheme?
So the maximum limit is 100 million. Yes, and the turnover over 75 million gets referred. So if your turnover is under 75 million, we can go on to facility. If over, we look to the open market.
Perfect. Thank you. I think that needed to be answered and referred back to the scheme from those beginning slides that you gave us. We will be sharing an updated brochure with all the members in terms of their additional covers, extensions, what's covered or not. As Terry has outlined here, we'll share all the slides with everybody. But anything last word from either one of you before we say goodbye?
No, I think Andrea summed it up beautifully, you know, in her closing. That is, AI is the enabler. You must use it. It's the way of the world. Just use it responsibly. It's reasonable. Take the mitigation steps. And hopefully you never have to see me again on the claim side.
Okay, great. Thank you so much. We apologize for where there were sound issues, and we will address that for future. Sorry, ladies, there were some sound issues, but we didn't want to keep interrupting. And yeah, we live and learn as we move forward. But again, thank you everybody for joining us. We'll share the presentations, the copy of the recording, and we hope you have a wonderful, productive July month moving forward. And thank you for your time, Andrea and Terry, once again. Thank you, Wahida, for your help. Thanks, members.
Thank you, everyone.
Thank you.